previous session, in previous sessions, we have learned Section 23, 24, 25 of Companies Act 2013, which are related with the uh, type of types of prospectus and then powers of SEBI, and Section 25 deals with the prospectus. Now we are going to learn the incidental matters to be stated in the prospectus in Section 26 of Companies Act 2013. Okay. Here we are going to deal with contents and requirement as to prospectus. Requirements as regard to date, sign, and contents to be included in the prospectus as have been mentioned in subsection 1 of Section 26, where prospectus shall be dated and signed and shall state such information and set out such reports on financial information as may be specified by Securities and Exchange Board of India in consultation with central government. Proviso to subsection 1 says the regulations made by SEBI in respect of such financial information or reports on financial information shall apply until the SEBI specifies the information and reports on financial information under section 26, subsection 1. The declaration shall be made affirming the compliance of the provisions of this Act, that is Companies Act 2013, then a statement shall also include to the effect that nothing in the prospectus is contrary to the provisions of Companies Act 2013, Securities Contract Regulation Act 1956, and Securities and Exchange Board of India Act 1992, and rules and regulations made under above three statutes. The provision of Section 26, subsection 1 shall not apply if the prospectus issued to existing members or debenture holders of a company and a prospectus issue relating to the shares or debentures which are in all respect uniform with the shares or debentures previously issued for the time being dealt in or quoted on recognized stock exchange. The explanation of subsection 3 of section 26 deals with the date of a publication of prospectus. It says that the date indicated in the prospectus shall be deemed to be the date of its publication, having of signed copy with registrar. Subsection 4 of section 26 deals with deals with the filing of a signed copy or with the registrar of the prospectus. A prospectus shall not be issued unless a signed copy of such prospectus has been delivered to the registrar for filing. This copy shall be signed by every person who is named as either director or proposed director in such prospectus. Duly authorized attorney can sign in representative capacity. For example, Ms. Sanika, Executive Director of leading fintech company, has to fly to Davos in Switzerland to attend World Economic Forum meet, while company secretary of the company intended to file a copy of prospectus with the registrar upcoming. Ms. Sarika authorized in writing Mr. Gautam for signing of such copy on her behalf. Date of filing of copy of prospectus with registrar is important in context of concept of validity of prospectus for issue, discussed under section 26, subsection 8, which we will see later. Conditions in regard to export statement in prospectus, the subsection 5 deals with the condition in regards to the export statement. A prospectus issued under section 26, subsection 1 shall not include a statement purporting to be made by an expert if any of following conditions made. If he is engaged or interested in the promotion, management, and formation of the company, or if the expert has not given written consent to the issue of prospectus, or he has withdrawn the consent before the delivery of copy of prospectus to the registrar for filing. A statement to that effect, non-existence of condition if experts statement is included shall also be included in the prospectus. Purpose of subsection 5 is to ensure independence of expert to protect the financial interest of prospective investor who may invest in company after relying upon the statement of such expert. An expert as per Section 2, Clause 38 of the Act includes an engineer, a valuer, a chartered accountant, a company secretary, a cost accountant, or any other person who has the power or authority to issue a certificate in the presence of any law for the time being in force. Disclosure on the face of prospectus. Subsection 6 of Section 26 deals with the disclosure on the face of prospectus. Prospectus issue under subsection 1 shall on the face of which state and specify that a copy has been delivered for the filing to the registrar under subsection 4 of section 26 and documents required by this section to be attached to the copies so delivered and or refer to statements included in the prospectus. We specify these documents and validity of prospectus for issue. Section 26 subsection 8 deals with the validity of prospectus for issue. A prospectus is considered to be valid for issue only if 90 days has not been lapsed from the date on which copy thereof is delivered to the registrar under section 25 subsection 4. The date of issue is important for many reasons, one of them being the value of securities keeps changing. If 90 days have expired after filing of prospectus, it's better to send a fresh copy of prospectus to register under Section 26, Subsection 4 to avoid the penalties imposed under Section 26, Subsection 9. Validity of prospectus for issue. Subsection 9 deals with validity of prospectus for issue, the penalty related to with the contravention of the provisions of Section 26. The company and every person who is knowingly a party to the issue of such a prospectus shall be punishable with a fine of rupees 50,000 to rupees 3 lakh. The board of directors of a pharmaceutical limited has allotted shares to the public by issuing a prospectus that is not filed with the registrar of companies. In this regard, it is noted that the public company can issue securities to the public only by issuing a prospectus under Section 23, subsection 1, clause A of the Act. Further, Section 26, subsection 4 requires that no prospectus shall be issued unless a duly signed copy of prospectus forwarded to registrar for filing. In this case, the company has issued the prospectus in violation of the provisions of Section 26. Hence, company as well as the person who is knowingly a party to this will be punishable with the penalty under Section 26, subsection 9 of this Act with the fine of rupees 50,000 to 3 lakh rupees. Statement, then we will see a true and false. They have given a statement that a copy of prospectus submitted to the registrar for filing need to be duly signed by majority of directors. It is a false. It should be signed by it should be signed by every director or proposed director mentioned in the prospectus. Our duly authorized attorney can sign in a representative capacity. Now we are going to learn the variation in terms of contract or objects stated in prospectus in Section 27. Section 27 deals with the variation in terms of contract or objects stated in prospectus. Subsection 1 provides the terms of the contract referred to in a prospectus or objects for which the prospectus has been issued can be varied, but only with the authority of the company given by it in a general meeting by way of special resolution. First proviso to subsection 1 requires that the prescribed details of the notice which has to be given to the shareholders are to be published in newspapers, one in English and one in vernacular language circulating in the city where the registered office of the company is situated, indicating clearly the justification of such variation. The second proviso to subsection 1 also prescribes that such company is not to use any amount raised by it through the prospectus for buying, trading, or otherwise dealing in equity shares of any other listed company. Subsection 2 provides that the dissenting shareholders, as are those who did not agree to the variation, are to be given an exit offer by promoters or controlling shareholders at such exit price in such a manner and condition as may be prescribed by SEBI by making regulation for this purpose. For example, in Swift Pharma Limited, after issue of prospectus willing to make a variation in object of issue of prospectus due to change in the industry brought by COVID-19 among other dynamic of pharma industry. What is your piece of advice to Insud Pharma Limited? In a given case, Insud Pharma should authorize the changes to special resolution pass at general meeting, and copy of notice that is given to shareholder for such variation shall be published in a newspaper along with the justification of variation. If any shareholder shows dissent, then exit option shall be provided in accordance with the guidelines issued by in this regards by SEBI. Now, once funds are raised through a given prospectus, the principle of doctrine of ultra vires mutatis mutandis comes into play. The company has to use the funds strictly in accordance with the prospectus. But if in any case variation need to be made, then such a deviations are required to be approved by the investors, and recall option need to be given to the dissenting investors. Deviation regarding use of proceeds or proceeds of issue for buying, trading, or other redeeming equity shares of any other listed company is not permitted in any case. Procedural aspects. Rule 7 of companies, Prospectus and Allotment of Securities Rules 2014, Sub-Rule 1, provides for special resolution to be passed through postal ballot and contents to be included in notice. Further, sub-rule 2 provide the advertisement of the notice for getting the resolution passed shall be in form PAS1, and such advertisement shall be published simultaneously with dispatch of postal ballot notices to shareholders. Accordingly to sub-rule 3, the notice shall also be placed on the website of the company if any. In case of variation in terms of contracts or objects in prospectus, which of the following statement are true? Ordinary resolution passed at a general false. Notice given to the shareholders shall also be published in the newspaper. Yes. Amounts raised can be invested in only into the shareholders. No. Only two shall be found which are not true. Not true. This is not true. This is not true. I can use 1 and 3. 1 and 3 only. Oh, now we are going to learn offer for sale. Offer for sale of shares by certain members of a company, Section 28. So Section 28 of Companies Act 2013 deals with the offer for sale or offer of sale of shares by certain members of the company. Subsection 1 provides that a member or members of the company in consultation with the board of directors may offer whole or part of their holding of shares to the public in accordance with the provisions of the law for the time being imposed. Other subsection 2 provides that the document by which the offer of sale to public is made shall be treated as a prospectus issued by company. Hence, all the provisions apply accordingly. At last, subsection 3 highlights the members' responsibility in matter of sale under subsection 1. It provides the members, whether individual or corporate or both, whose shares are proposed to be offered to the public shall collectively to authorize the company to take all actions on their behalf for carrying out the transaction. They also have to reimburse the company for all expenses made by it on this matter. Procedural aspect. Rule 8 of the Company's Prospectus and Allotment of Securities Rule 2014. According to the Rule 8 sub-rule 1, the provisions of the Section 23 to 41 of this Act and rules made thereunder shall be applicable to an offer of sale referred to in Section 28, except for the provisions relating to minimum subscription, minimum application value, and any statement to be made by Board of Directors in respect of utilization of money and information which cannot be complied and gathered by the offer or with the detailed justification for not being able to comply with such provisions. Further, Rule 8, Sub-Rule 2 requires that the prospectus issue under Section 28 shall disclose the name of the person or persons or entity bearing the cost of making the offer of sale along with reasons. Now we will have a question illustration plan A. In case of a super fixed limited, some of the members of the company offer a part of their holding to the shares to the public in consultation with the board of directors, wherein company took all actions on their behalf for carrying out the transaction. Company incur the expense of 3.2 lakh for carrying out such a transaction. Can company recover the amounts from incurring full from such member? Yes. The members who offer whole or part of their holding of shares to the public in consultation with the board of directors shall authorize the company to take all actions on their behalf for carrying out the transaction and vow to reimburse the company for all expenses made by it on this matter. Now we will have section 29. It's all about public offer of securities to be in a dematerialized form. Subsection 1 of Section 29 has overriding effect to any other provision of this Act. It provides that every company making a public offer and such other classes of companies as may be prescribed have to issue their securities only in a dematerialized form by complying with the provisions of the Repositories Act 1996 and regulations made under it. Subsection 1A, inserted in 2019, provides that in case of a prescribed class or classes of unlisted companies, the securities shall be held or transferred only in a dematerialized form by complying with the provisions of the Repositories Act 1996 and regulations made under it. Further, subsection 2 provides that any other company may convert its securities into dematerialized form or issue its securities in a physical form in accordance with the provisions of this Act and issue of the securities in dematerialized form in accordance with the provisions of the Depositories Act 1996 and the regulation made thereunder. Rule 9, dematerialization of securities, and 9A, issue of securities of dematerialized form by it unlisted public companies of companies, prospectus and allotment of securities. 2014 is relevant for the procedural aspect pertaining to the public offer of securities to be in a dematerialized form. Now we will see the section 30, which is about advertisement of prospectus. Where an advertisement of a prospectus of a company is published in any manner, it shall be necessary to specify therein the contents of the memorandum as regards the following. Those are the objects, liability, names, number of shares subscribed for the resolution by the signatories and capital structure of the company. So the contents of a memorandum to be published in the newspaper and the advertisement. And those are objects, liability of the members and the amount of share capital of the company, names of the signatories to the memorandum and number of the shares subscribed by those signatories and capital structure of the company. Now we will see the sale prospectus and trade hearing prospectus. Section 31 deals with the sale prospectus. Meaning of sale prospectus, explanation to section 31. The expression shelf prospectus means a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without the issue of further prospectus. New optional prospectus. A company is required to issue a prospectus each time it accesses the capital market. It leads to unnecessary repetition of the company for a company which makes more than one offer of securities in a year to mobile funds from public. A way out is sale prospectus, which remains valid on the sale for a specified time period during which offers for securities may be made by a company to the public without going through the arduous exercise of issuing fresh prospectus every time. Filing of share prospectus with registrar subsection 1 of section 31 deals with share prospectus may be filed with registrar at the stage of the first offer of the securities by class or classes of company as the Securities and Exchange Board of India may provide by regulations in this behalf. It has to indicate a period not exceeding 1 year as the period of validity of such sale prospectus. The period of validity is to commence from the date of opening of the first offer of the securities under such prospectus and in respect of any second or subsequent offer of such securities issued during the period of validity of such prospectus, no further prospectus is required. The filing of information memorandum with shell prospectus subsection 2 of section 31, a company filing a shell prospectus shall be required to file an information memorandum with the registrar within the prescribed time prior to the issue of a second or subsequent offer of securities under the shell prospectus containing all material facts relating to the new charges created, changes in the financial position of the company as have occurred between the first offer of securities and the previous offer of the securities and first offer of the securities or the previous offers of the securities and the succeeding offer of securities and such other changes as may be prescribed. Proviso to subsection 2 provides a safeguard in case of changes to applicants to make the payment in advance. It is provided that where a company or any other a other person has received application for the allotment of securities along with the advance payments of the subscription before the making of any such change, the company or the other person shall intimate the changes to such applicants, and if they express a desire to withdraw their application, the company or the other person shall refund all the monies received as a subscription within 15 days thereof. Procedural aspect, Rule 10 of company's prospectus and allotment of securities, Rule 2014, the information memorandum shall be prepared in Form PAS2. It shall be on file with the registrar along with the P as provided in company's registration office and Page Rules 2014 within 1 month prior to the issues of the second and subsequent offer of securities under the share prospectus. Information memorandum together with the share prospectus is deemed prospectus where an information memorandum is filed every time an offer of security is made under subsection 2. Such memorandum together with the share